Welcome back to Your World. The Judicial Services Commission is deliberating on the future of the Supreme Court. It held interviews in Cape Town.
Our contributing editor, Vuyo Mvoko, is in Cape Town and sat in on the interview process. We now cross to him for highlights from that panel.
Well, thanks very much indeed, Tabila. Yes, we're coming to you live from our Seapoint studios here in Cape Town. I'm here for the next few days listening through the interviews that, as you said, are being conducted by the Judicial Service Commission, where they're looking for persons who are fit and proper to be judges in some of the highest courts in our country. Well, as everyone knows, the Judicial Service Commission is comprised of judges being presided over by the Chief Justice, Mogoeng, but also he has, of course, fellow judges who are part of the commission. And so it also constitutes of members of parliament from both houses, from the National Assembly as well as the National Council of Provinces. There are, of course, also several other individuals drawn from the profession itself, from some of the bodies that are operating within that space. Well, the interviews began in earnest last night. They were due to take place today, but had to be moved forward because of the debate many of you would know about around the impeachment, the motion to impeach President Jacob Zuma, which, as everybody knows by now, did not carry. So what that meant yesterday is that the interviews had to start earlier. So they started in the evening and went through till around midnight. Now, what we want to try and do this evening is to play some of sound bites from that process, from what happened last night, but also to try and tease some of the issues that we believe are going to perhaps play a significant role in determining the future of our courts, but also it gives us a sense of some of the issues that members of the Judicial Service Commission feel particularly strongly about. Now, to get us going, here's a clip which spoke to the issue of politics versus the law, and perhaps how judges should approach that particular issue in South Africa today. Let's take a listen.
You're saying when a judge makes a judgment, must take into consideration politics?
Yes.
Is that what you're saying?
The politics of the subject matter. So how, for instance, how the budget is allocated, how the political system works, for instance. Yes.
So if a judgment, what is more important in this judgment? Is its political correctness or its legal correctness?
It's not necessarily mutually exclusive.
Can a decision be politically correct but legally wrong?
Well, it has to be legally correct.
Can a decision be politically correct and legally wrong?
It has to be legally correct. If the politics inform the legality, then the politics must be taken into account. If the politics is irrelevant, it doesn't inform the legality.
Well, Lauren Korn is a lecturer at the University of Cape Town, and she's going to help us go through some of the issues that have been raised during those interviews. Well, the first being this dilemma: is it really, Lauren, an issue for South African judges, politics versus the law, or should it be an issue?
Is it an issue? I think inevitably it is. I mean, if we are frank, the simple answer is that the courts are meant to serve as fora of principle. Policy should not really enter the courtroom. Judges are meant to decide legal questions on the law. And I think, as the candidate there said, politics cannot inform the legality. I think that's certainly true. Of course, the judges, as we know, are not elected by the people, so-called counter-majoritarian dilemma. They don't have the stamp of the people's mandate in that sense. And so policy should not be happening within that forum. It's a legal forum. However, of course, the court's ultimate responsibility is to uphold the Constitution and the law. But within this Constitution, as you know, within the Bill of Rights, here it is, we have a host of competing rights, and that includes, for example, social economic rights, like the right of access to adequate housing. And as we've seen from our jurisprudence, although the courts decide these matters on the law, inevitably policy seeps in here, and it's a murky terrain, and it's a difficult area to navigate for judges, and it requires a striking of a very delicate balance. Similarly, as we've seen now with this landmark Nkandla judgment, courts, and in particular the Apex Court, our constitutional court, is called upon to decide disputes between organs of state and between the arms of government. Now, inevitably, that puts courts in a tricky position where politics does seep into the courtroom. So judges, as a result of that, have to tread carefully. They have to tread slowly. They have to exercise judicial deference where it's called for. And of course, we can talk a bit later about the separation of powers, but they have to, in upholding the Constitution and indeed the separation of powers, they too must respect that. They must not overstep. So what the candidate has said there is, I think, I don't know if I must make an observation on that, but I suppose politics cannot inform the legality, but somehow we cannot either insulate the judging process entirely from what is going on, I don't know if that answers your question.
Yes, it certainly does. But as far as you can recall, have we had situations in South Africa recently where perhaps some people or scholars may have thought that perhaps judges are treading on maybe dangerous territory, playing politics instead of applying the law?
Yeah, I think that has been an observation. I think that I don't always envy the courts. My view is that, on balance, having perused benchmark constitutional court judgments, my sense is that, on balance, they're striking this balance very, very well. I think it's a challenging one to do, and I think that their ultimate guiding compass is the Constitution, which they have to defend and uphold, and that is what they are doing. And so yes, there hasn't been an argument to be made, and I think certain judges are perhaps guilty of that. But I think it is a difficult terrain to navigate, as I said.
Well, which brings us then to the issue of the separation of powers. I think a lot of politicians have said as much, that they've become a bit uncomfortable. They somewhat, especially the ruling party, seem to feel that the judiciary is being drawn to deal with what are essentially issues that should be best left to the Parliament in most recent instances.
Yeah, these are tricky things. So in terms of the separation of powers, for the benefit of the viewers that aren't familiar with these terms, really what it comes down to is that state authority is divided up into three spheres. We've got the lawmakers, the legislature, the executive, who are essentially our policymakers, and then the judiciary, who judge questions of law, decide questions of law. And our Constitution, although not explicitly, it's an implied component of our Constitution that we have entrenched this principle, or this doctrine, of separation of powers. And really, just to summarize in a nutshell, the two main aims of this doctrine. The one is, of course, it flows from a recognition that, as the famous adage goes, absolute power corrupts, and absolute power corrupts absolutely. So we don't want to center power in any one body or entity. So you diffuse power to ensure that power checks power, and thereby ensure that fundamental human rights are upheld and respected. Because, of course, as we saw under apartheid, where power isn't diffused in balance, human rights are compromised. So that's the one aim. The other aim is to ensure enhancement in government efficiency and functioning. The idea being that let the best man do the job. Judges should not be policymakers, and policymakers should not be judges. And judges must be aware of that. I think it was Judge Hlophe, who once said, a judge is not a jack of all trades. So when it comes to these kinds of cases, where you're dealing with disputes between arms of state or organs of state, where you're dealing with socioeconomic rights and tricky policy questions, how much housing to allocate, how much social assistance to allocate, judges need to be very cautious, and there's a time to be bold, but there's a time to be cautious. But they must do that within the framework of the law.
Now, a question was asked by one of the members of the JSC last night. It went along the lines of what should ideally happen when one arm of the state either second guesses or deliberately ignores decisions of the courts.
Yes, I mean, this is a hot talking point, actually.
Exactly.
And we've seen it play out most recently with the recent al-Bashir saga, for example. So do you want me to proceed on that? Or?
Yes,
yeah.
Yes.
So, of course, the courts don't have, in the separation of powers, the courts don't have the power of the purse, the power of the sword. They don't have the might of an army. They can't raise their own money. All that judges really have is a kind of moral authority, which stems from the esteem that their judgments generate and the people affected by it, and of course in the public. So it's necessarily linked to public confidence. And public confidence in the judiciary will be undermined if the judiciary is perceived to be not independent, but also if court judgments are not respected. So it is vital that court judgments are respected. That's all that judges have, right? And if we see contempt of court, flagrant disregarding of court orders, what does that say to the people? That these final arbiters of these disputes, these guardians of our constitution, are being disregarded. It's deeply worrying. So, for example, the recent al-Bashir case, where it was made quite plain on that judgment that the executive acted in breach of a court order. That is contempt of court, and that, of course, is a crime. And I believe the judge in that matter directed the appropriate authorities to investigate the matter. Whether or not that was in fact being done or is in fact being done is a different story.
Well, the issue of impunity did actually come up yesterday during those interviews. Let's take a listen to this clip on impunity.
How do you account for taking too long to finalize what could have been finalized expeditiously? How do you account for taking too long? Should we be tolerable? Should we tolerate the culture of impunity when we deal with it, or when we deal with, say, corruption in general? Should we be soft so that we don't sound too harsh to impunity or corruption as a general concept that we are explaining to people need to be dealt with? And to what end?
Chief Justice, we're not to be soft. We are to draw very firm lines relating to what is acceptable and unacceptable conduct under the Constitution.
Yes.
There is absolutely no room for manoeuvring or being soft on people who go beyond the powers or simply ignore the powers or the obligations the Constitution places on them, and that's true of everybody.
And of course, even tone must be contextualized. You don't just find a word and run with it, should you?
Absolutely, I think that's quite correct, sir.
I think it's important. Lawyers must do that.
Well, some interesting comments there from the I'm still trying to, figure out why the Chief Justice, felt the need to raise this point. What do you think was going, through his mind?
Well, I think he made a very bold move, of course, in recent times, calling a meeting between senior members of the executive and the judiciary, which was a landmark meeting. I think he wants to make it known that the judicial space needs to be protected, that the courts need to feel emboldened to speak out against corruption and uphold the law and the Constitution. That much is required by our Constitution, and our courts are the guardians of that. So where, as the candidate in question said, firm lines must be drawn, and that is indeed true. If people violate this Constitution, whether you're the commander-in-chief or the man on the street, you need to then be held accountable for it.
He touches on the issue of language. I want us to take to listen to another clip which was specifically around the language that gets used in court. Let's take a listen.
Share with us your opinion about the tone and the language of the court when it reasons in giving the judgments. For example, the recent Constitutional Court judgment, when it was conceptualizing the concept of the rule of law, it talked about the sword that is ready to chop off the head of the stiffened necks. The Supreme Court of Appeal, in the King's case, talked of a despotic king, which was tyrannical. So, how does that language contribute to the fairness of the manner in which the courts deal with the litigants before them? The other question, as somebody, as I understand that you don't have a background on customary law, how is your background going to assist the court in the infusion of customary law into the general framework of the law, in the interpretation of the law?
Well, the first question relates to tone. I think it's very important that when one writes a judgment, that the tone is one which is not hostile without a proper basis for being hostile and using hostile language. I think if one can draw an inference from facts which support the kind of metaphorical use of language that you've given examples of, that might be appropriate. I think courts need to be quite careful, because once a court has said something, particularly if you're the final and apex court, there is no recourse to having that corrected. In lower courts, there is a recourse to having that corrected by way of an appeal. So I think the tone and use of language is of critical importance, so that you're communicating very accurately and with restraint findings which are valid in law and which can be made as a result of the facts placed before you as a judge.
Why would that point be important, Laura? I mean, why would a member of the JSC feel that the language that judges use in court is just as important as everything else?
Look, I think, as the candidate in question said, tone is incredibly important. Judging is in a way, it's an art and a science, I suppose. Judicial officers are supposed to be measured, they're supposed to be fair, they're supposed to exercise a degree of restraint. But then again, as I said, is it art, is it science? There's a time for boldness, and I think perhaps this is one of those times, where if somebody flagrantly violates the Constitution, although the court needs to be measured with its tone, it should be free to indicate as much. And it indeed must indicate as much. But I think it's quite correct. The metaphorical use of language, it can be very powerful. And so, as the candidate in question said, the courts must ensure restraint. And this flows from the separation of powers, right? So the courts must not be perceived to be overreaching, must not be perceived to be politicking. And I guess, linked to this is where he spoke about a recourse for correction and an apex court versus a lower court. That's an important point, because who guards the guardians? How do we check the judges? I mean, that's the sort of timely, seemingly endless debate. And because the judiciary is a different beast qualitatively, because they are not, as I've said, they don't have the power of the sword, the purse. The accountability mechanisms are necessarily different, because we have to ensure the independence of our courts. So the way in which we check them is through example, public reason giving, sound reason giving, the fact that they can be subjected to academic and other criticism, the fact that there is a doctrine of precedent, they have to follow decisions of higher courts and courts in the same division, and of course the fact that there is an appeal process. But when it comes to the apex court, when the Constitutional Court has had its say, I mean, that is the highest court in the land. Does that close the debate? There's an argument to be made that allows for a structured dialogue, a structured response from the other arms of state affected. Not an informal chat, but the fact that there's still room for the executive and the legislature to tailor their response within which the court requires.
But I mean, how do other jurisdictions do this? What do other nations do to make sure that even the apex court sort of has, there are those checks and balances, as you call it?
Well, yeah, I mean, in fact, the JSC process itself is that check, is the as you've said, the composition of the body, it's a hybrid body, it's made up, there's political input. So that is a form of check on the process. It's not, but it cannot be that the judges and that judgments are subjected to the views of the majority in that sort of sense, because that would be inappropriate. And that would encroach upon judicial independence. And of course, if our courts lose their legitimacy, then the entire democratic edifice will crumble. That would be catastrophic. The courts are the most immediately available resource for the people to uphold their rights.
Well, we don't have time to play this clip because we have run out of time. But another issue that was raised quite strongly was the issue of access to justice. How the rich and the powerful in society are able to access justice, access it easily, because money can buy, almost everything. And where that leaves the poor and the vulnerable. Do you have a view on that?
Yeah, I mean, my view is that it is, of course, it causes great despondence. It makes me greatly sad, actually, that the people that really need access to justice are really those that don't get it. So we need to look at how we can better resource legal aid clinics, how we can incentivize the giving of pro bono legal advice or mandate it on a greater scale. That is something we need to seriously consider. And also, I think within the judicial space, within the courtroom, practitioners need to not be intimidated, judges need to be fair, need to be measured. We need to protect that space in order to protect access to justice as well. So I think that is incredibly important, and I don't quite know the solution to that, but it's something that I hope we can find.
Well, a related issue, in the age of television, people watching these cases,
Yes.
on television, there was a whole debate about whether or not it's a good or a bad thing.
Yes.
Your comments on that, very briefly?
Again, it's all about the balance, right? So on the one hand, it enhances transparency, accountability to an extent. It's another check in a way. It makes access to justice more readily available. It brings justice to the people. The other argument, of course, is that it may make judges and practitioners act with a little bit more trepidation, a little bit more fear. Always in the balance.
Well, thank you very much, Lauren.
Thank you, Vuyo. It's lovely talking to you.
From the
Thank you so much.
University of Cape Town, really helping us dissect some of the issues that came up during last night's interviews of judges that want to serve in the Supreme Court of Appeal. Well, that's where we're going to leave it for this evening. Thanks very much for watching. And with that, it's back to you in the studio in Johannesburg.
And that was our contributing editor, Vuyo Mvoko, joining us live from Cape Town.
Yes, Vuyo was speaking to Lauren Kohn. She's a lecturer at UCT, and they were looking at how interviews take place within the judicial services. We'll have more news for you at the top of the hour.